Welcome to the midweek edition of Legal AF. I'm your host, Karen Friedman Agnifilo. Both Michael Popak and Ben Meiselas are off for Thanksgiving, so I decided to do this with a guest tonight, and I have a very special guest. His name is Daniel Alonso. He and I have worked together in the Manhattan DA's office. He's an attorney, and he was the former chief assistant of the Manhattan DA's office under Cy Vance, a position that I held after him. Dan also was a prosecutor at the Eastern District of New York, which is a federal DOJ prosecutor, and a supervisor there as well. He has a deep breadth of experience in white-collar criminal law and in prosecuting organizations. And so this is going to be an excellent opportunity to have him with us tonight, because he literally wrote the memo at the Manhattan DA's office on when to prosecute a corporation. So who better than to talk about the trial of the Trump Organization, where the people have rested and it's going to be going to the jury soon. Summations are Tuesday. So Dan is currently in private practice. He works for the Buckley law firm, and he'll tell us all about what he knows about a couple of topics. We have three today. We're going to talk about the Trump Organization trial at the Manhattan DA's office. We're also going to talk about Tuesday's 11th Circuit three-judge panel that heard the Mar-a-Lago case, the confidential documents case, and whether or not Judge Eileen Cannon overstepped when she appointed a special master. We're going to talk about that. We'll also talk about a former colleague of both of ours, Jack Smith, who is now the special counsel appointed by Merrick Garland to handle both the Mar-a-Lago documents case as well as the election interference case, also known as the Jan 6 case, however you want to refer to it in shorthand. But there's a lot going on this week, including the fact that the Supreme Court has released Trump's tax returns to the House Select Committee, and Trump's not happy about that. He's been making all sorts of noise about that as well. What we're going to start first by welcoming Dan to the show. Hello, Dan. Thank you so much for agreeing to be here. I just couldn't think of a better person to talk about the prosecution of the Trump Organization, given the fact that this was something that you felt so passionate about, something you've always felt was something that prosecutors should do more of. And like I said, you literally wrote the memo at the Manhattan DA's office. So welcome.
Well, hi, Karen. Thank you very much. I'm a big fan of your show, so I'm very excited to be here. So look, when you say I wrote the memo, it's technically true. I authored the memo, right? Obviously, I had help from people in the office, but it is not it's something that's very well understood in the Justice Department, in the federal world. So I basically took the concepts from the federal policy on prosecuting organizations and translated them to our beloved Manhattan DA's office, and that's why there's a memo on charging organizations, which I can talk about if you want, but I don't want to take all the credit for it.
Well, before we talk about the actual trial, just talk a little bit about what goes into a decision. Some people think, how do you charge a business? How do you charge a corporation criminally, right? It's one thing to bring something civilly and it's monetary damages, but when you think about a state court or federal prosecution, you think about it's criminal, and you think about bringing charges against a human being, and then if they are found guilty, obviously they put handcuffs on them and you put them in jail or prison. Tell us how that works. Obviously you can't fingerprint an organization, so they don't have a rap sheet. Tell us how that works, and what are the special considerations that go into whether or not to charge a corporation or an organization.
Sure. So we start with the proposition that under the laws, as many people know, corporations are considered persons. So persons like human persons or corporations, which are, legal persons, can commit crimes. And the law has sort of a special set of rules on when you can charge and when you can't charge a corporation. And all you're doing, obviously you can't arrest them, you can't fingerprint them, as you said. All you're doing is you are issuing once you file the charges, a criminal summons, and the corporation goes to court and appears by counsel. So I can go represent and have represented corporations in court. And that's how the work gets done. And the penalties are prescribed by law. Frankly, in New York State, they're not particularly heavy for companies. They're fines and they're, what's called a conditional discharge that I could talk about in a minute. But the key thing for your listeners to understand is that the entire ballgame for corporate prosecutions is collateral consequences. The reason why we have this memo in the DA's office about when we should and when we shouldn't charge corporations is because lots and lots of things can happen to the corporation well outside of the sentence that the court might possibly hand down. For example, if you are a company that is licensed by a state entity, let's say you sell pharmaceuticals, right? Or you are a company that has government contracts. You're a construction company and you work for the city of New York all the time. A conviction could well be ruinous. You could lose the license, you could lose the contracts. Let's say you're a law firm, or like what happened a few years ago with KPMG, the big accounting firm. Reputation is everything. If all of a sudden you are a convicted felon as a law firm or as an accounting firm, your clients are going to run for the hills. So it's very important, and corporate defense lawyers always are very careful to advise their clients on, what to do if the government is investigating you. It's normally, and I say normally because we're going to talk about Trump, it's normally a very, very big deal. With the Trump organization, nothing is normal about the way this case has been handled.
So tell us a little bit about the case and about the trial and just what's gone on.
So first of all, you asked earlier about some of the considerations, right? So it has to do with the Trump organization. Under the policy of the Manhattan DA's office, it was not even a close call to charge the Trump organization because some of the considerations are, have you cooperated with the DA's office? Have you self-reported, criminal conduct? Have you gotten rid of wrongdoers? Have you disciplined people who have done bad things? Do you have a history of having done other bad things? Right? Those are the kinds of considerations. Trump organization fails on pretty much every one of them, right? So we've got a CFO gets prosecuted. He is convicted by his own admission of 15 counts of accounting fraud, and the guy still works for the company. I don't think he's the CFO anymore, so I don't think he signs the financial statements. But that would be sort of unheard of in a regular federal, company that is being investigated and trying to present to the government why it shouldn't be prosecuted. God forbid we lose our, stock brokerage license or something like that. With the Trump organization, I don't think they cared. I don't think they cared about reputation. I don't think their whatever government contracts they had or don't have are not public because they're not a public company. So I don't know exactly what the collateral consequences can be, but it's obvious that they didn't particularly care. And in my opinion, they're going to trial, because they have an audience of one. They just want to make sure that, they're able to argue that Donald Trump had nothing to do with it, is my guess.
But would you agree with me, Dan, that the prosecution has to show that the corporation benefited in some way in order to be held liable? In other words, just, let's say Alan Weisselberg was doing this just for his own benefit and there was no benefit at all to the corporation. What's the difference between personal liability and the Trump organization liability? And what does the prosecution have to prove here? Because I know Weisselberg has been saying this was just me. And only me.
No, you're exactly right. And the factors don't even come into play, the ones I just talked about, until you deal with actual criminal liability in the first place. So a person, of course, commits a crime when they do an act and they have the right mental state. A corporation can only act through people. So the law in New York, which is based on a model law called the Model Penal Code, basically says that for a felony, a crime, for the company to be liable, the crime has to be committed by what's called a high managerial agent acting within the scope of his duties and for the benefit of the company, at least in part. So the law says that you're right. Weisselberg would have to be acting for the benefit of the company. The first part of that test is pretty easy when the CFO admits that he committed the crime, right? So he's a high managerial agent. So it has to be either committed or recklessly tolerated by the board of directors or by a high managerial agent. Weisselberg counts. I don't think anyone's disputing that in this trial. So the only question here is, did he commit these crimes, which everyone again agrees he committed? Did he do that, at least in part, for the benefit of the Trump organization? So Clearly, it was for his benefit, at least in part. The question is, because he got the additional salary that came with not paying taxes. So what is it that makes it in the benefit of the Trump organization? That's the issue at the trial. And I think the question there is, is there some theory in which this benefited the organization? I think it's pretty clearly right. I haven't watched the trial every day, so I don't know exactly what the testimony was. But when you're getting to pay an employee more than you otherwise would because the taxpayers are subsidizing that salary, that's a benefit to the company, whether or not it's also a benefit to the employee. In this case, by the way, there's one additional piece, which is it's a benefit not just to an employee. He's not just any old employee. He's the guy everyone's been saying knows where the bodies are buried. Whether that's true or not, and Michael Cohen is the guy that mostly says that, it does have the appearance of, this is them giving, a nice tax benefit, a nice salary benefit to a trusted employee. And P.S., they didn't fire when he pled guilty, which most reputable companies would do when their CFO admits to accounting fraud. That's a big deal.
Yeah, no, it's a really big deal. And so at the trial, they immunized one person, and they had Alan Weisselberg cooperate. And so can you explain kind of the considerations that go into those decisions and what your thoughts are on the Weisselberg cooperation, given that he wouldn't give up Trump?
Well, usually cooperation is very different than Weisselberg. This case is unique in every way. I've never heard of a cooperation agreement like Weisselberg's, and I think Weisselberg's lawyer and Weisselberg would say he doesn't have a cooperation agreement. He basically agreed to plead guilty to the charges against him. The judge promised him that if he tells the truth on the stand, he's going to get 5 months in jail, and if he doesn't, all bets are off, and he can get up to the maximum, which I think is 5 to 15 in this case. So it's very different than a normal cooperation agreement. In a normal cooperation case, what I would expect when I was a prosecutor, what I would expect is somebody would be facing some level of criminal liability and would want to try to get leniency from both the government and the court. And for that reason, the prosecutor, I would be looking for them to come in and first tell me information. It's called a proffer information that might be useful. And then I and my team would get to evaluate it, see if it's truthful, see if it might be helpful, see if it's complete, because lots of cooperators who are not well prepared by their lawyers come in and think they can only tell part of the truth. That's a very bad thing. See if it's complete, see what else they might know, like we might arrest somebody for a drug case and ask them about a homicide. That's very common. Might arrest them for fraud and ask them about corruption. So we find out all that, and only then do we make the decision, okay, we're going to offer them a cooperation agreement. And then the terms of that just have to do with what are the crime or crimes that they're pleading guilty to, what's the potential sentence, what kind of consideration will the government offer. In state court, oftentimes there's a fixed sentence that is promised if the person cooperates, not always, but oftentimes. In federal court, the sentencing is left up completely to the judge, but the government promises to write a letter that lays out all the good stuff that the cooperator has done to help the government. So it varies, but most significantly in a normal case, you want to talk to the person extensively before they plead guilty, and then you offer them a cooperation agreement that is written down. That's not what happened here.
So why do you think the prosecution did what they did and agreed to do this way? Did they need him? Did they need to get him out of the case? What do you think was the motive behind this?
I have my theory that my sort of pet theory, which I think I've probably talked about with you before, is that federal prosecutors have a 95% conviction rate plus 95 plus conviction. State prosecutors in Manhattan have a 75% conviction rate. That's not because the federal prosecutors are better lawyers than the Manhattan ADAs. It is
because they get to cherry pick their cases, Dan. We all know that.
No, it's partly
I'm
because
kidding. I'm kidding.
No, but it's absolutely true. And DAs have some DAs have kind of they take whatever cases come to them, but a real factor is uncertainty in state court. The system just is not as reliable in terms of the rules of evidence, the laws. There's a lot more that can go wrong, and it's unpredictable in state court. So when a state prosecutor is faced with a serious defendant like Alan Weisselberg, who's charged with serious crimes, and he's saying, look, I'll plead guilty to the whole thing. I just want to get some sentencing leniency from the judge. It's hard to pass up because you get the certainty of that conviction, of those convictions, and you get the certainty to know that he's going to jail one way or another. And on top of that, he's going to testify, quote, truthfully. I don't know what they can prove.
Why call him as a witness? Don't you think that kind of hurts their case?
I think that, again, I'm speculating. I mean, these are very good lawyers that are trying the case for the office, as you well know. But my guess is they wanted to get the issue of, was there a crime? Was it a high managerial agent? And what were the circumstances? They wanted to get that out there and not have the defense say, how come they didn't call Alan Weisselberg? They don't understand the facts of the case. They didn't prove it. So I think that's probably what they were thinking. A very reasonable view of this would have been, of course, you don't want to call Alan Weisselberg. And of course, you don't want to give him any leniency. I think he would have pled guilty either way, whether they were going to call him or not. I think he just knew he couldn't fight the case. The case was a very, very strong case against Weisselberg. So he knew he couldn't fight the case. If the DA got a little cooperation, I think they probably just said, all right, we'll take it because it'll prove most of the elements of the case.
So I read in the paper that the defense called an individual his last name was Bender, who was an accountant at Trump's long-term Mazars accounting firm. But what I read that I thought was interesting was that the prosecutors, the DA's office, prepped him, and he was going to be their witness. He prepped him for many, many, many hours, but ultimately decided not to call him and let the defense call him, and so that they could, I would assume, so they could cross-examine him, which is very different than direct examination, because, as you know, direct examination, if it's your witness, you just basically say, so then what happened? So then what happened? What happened next? On cross, you get to say, isn't it true that you falsified these things? Or isn't it true that you knew these things? You get to kind of ask questions very differently. And so sometimes prosecutors want to be in that position. And so that's why they did it that way. And that he testified for the defense. What did you think about that?
Well, as it was reported, this guy Bender, who's the longtime accountant from Mazars, he was going to be a government witness, and they decided that they didn't need him. That's what the reporting says. So that's not uncommon. I mean, every time a prosecutor or a lawyer, for that matter, decides to put a witness on, there's some peril, right? You're sort of opening up that witness to whatever questions the other side wants to ask, and you don't always know what that is. So the prosecutors here doubtlessly decided that they didn't need his testimony, and that if the defense called him, they would cross-examine him, as you said. I don't think they knew the defense was going to call him, but the defense did ultimately call him. Like I said, nothing is normal about this case. That wouldn't be all that normal. Another not normal thing, by the way, I don't know if you know this, but the defense and the prosecution prepped Weisselberg. So Weisselberg took the position, I'm not a government cooperator. I'll make myself available to anyone. And so his testimony was well choreographed in advance, meaning both sides knew exactly what he was going to say.
Very interesting. Do we know who's paying for his lawyers? Has that been made public?
I think the organization, or I saw somewhere that there were some conservative groups that were paying for them, but it's certainly not being paid out of pocket by Weisselberg or by any of these witnesses.
Yeah, and that comes out, right? I mean, that's not privileged, right? That comes out. Yeah.
By the way, with Bender, I read that the prosecutor brought out that Trump had major losses in a couple of tax years, 10, 15 years ago. It had like tens of millions of dollars in losses. I don't know why they did that. Donald Trump himself, I mean, not the organization. You try to hope that politics isn't being injected into here, and I doubt it, knowing these prosecutors. But, it's an interesting fact that made headlines that, now we know for the first time exactly how much money Trump lost in certain years. The whole he's not a good businessman theme that has been out there.
So I want to get back to what the prosecution has to prove. Okay, because as you pointed out, it's going to be easy to prove that Weisselberg was high enough up, that a crime occurred, but it has to be a benefit, right, to the corporation or some benefit. Do they have to specify which benefit? I mean, how does that work when this goes to the jury? Do they have to
They
say
have to
this
argue.
is
No, they have to argue to the jury that there was some benefit. Now, maybe they can come up with multiple ones, but the two that I've just come up with is, getting a taxpayer finance subsidy and paying a major employee of the corporation, right? I get to pay him more money because the taxpayers are subsidizing it because I'm not paying taxes on it like I'm supposed to. I'm willfully not paying taxes on it like I'm supposed
but
to.
who's not paying taxes on it?
The corporation is supposed to withhold taxes and supposed to accurately report what they're doing with the taxes. Instead, they are either misreporting it, not reporting it. I don't know the exact details of the evidence, but they're essentially participating in a scheme to defraud both the IRS and the tax department of the state of New York by not treating these benefits to Weisselberg as income to him as they're supposed to, and Weisselberg also not declaring it on his own returns as income, knowing very well what he was doing wrong.
But couldn't a defense attorney argue that, okay, but he chose to do it in different ways, right? I'm going to pay private school tuition, and I'm going to let him live in an apartment, and I'm going to lease the cars, and knowing that in those instances, it's the responsibility of the individual receiving this to pay the taxes. How does the organization benefit from that type of?
Well, there's two different things. One is the knowledge of intent of the organization. The other is their benefit. The knowledge and intent, I think that ship has sailed because the CFO has admitted that he had the knowledge and intent. And therefore he's a high managerial agent. That's it. There's no such thing as like the board of directors comes in and says, "Oh, I didn't ratify that." That's not the rule. The rule is any high managerial agent commits it or recklessly tolerates it. So that's one issue, the knowledge and intent. The benefit is a different question. And the benefit is, in my view, one of those two things. We'll see what Assistant DA Hoffinger argues next week. But I think the benefit is the taxpayer subsidized salary for the employee or the payments to keep happy a trusted employee, whether he knows where the bodies are buried or he's just a trusted employee. Either way, it's a way to funnel money to him, and that benefits the organization. So no doubt she'll argue the first one. I don't know if she'll argue the second one.
Yeah, very, very interesting. And so does the benefit theory have to match up the theory that was argued in the grand jury when he was indicted for this? When they were indicted, I'm just wondering
that gets into like a lot of inside baseball motion practice. If the indictment specified one thing and the prosecutor tried to prove a different thing, that could be what's called an unconstitutional variance, and it's a due process violation. But the prosecutors are too smart to pin themselves down to just one thing. So the indictment just says, if it even says for the benefit, I doubt it does. I haven't read it in a while since it came out. But they wouldn't pin themselves down to that. They would just say, and the judge would charge the jury, it has to be at least in part for the benefit of the corporation.
So interesting. All right. Well, I think that's really, really interesting information and insight on your part. Do you have any predictions on? Do you think they're going to be out long? Do you think it's going to what are your thoughts on?
Look, if they pick the reasonable jury, I think this is just a slow guilty plea. In other words, that's a jury conviction, which they essentially know is going to be a conviction. I think they just wanted to make the points they were going to make in court. So I think this is overwhelmingly likely to be a conviction. Now, people have been like fools before about predicting stuff about Donald Trump, but I think it's highly likely to be a conviction.
And does this in any way? How does this impact the Trump organization in any way?
And that's the thing. They've obviously, in a normal company, if you're a public company, it could impact your stock. If you're licensed by the SEC, by FINRA, and you trade and are regulated by the SEC, that can impact those issues. But for the Trump organization, I don't think they seem to care. They seem to be doing business overseas in the Middle East, where companies don't really care much about these kind of niceties that we care about so much in the U.S. They're not publicly traded. I don't know if they have any licenses. So I don't think they really care. Banks is another issue. Like, what is your bank going to do if you are a customer of a bank with presumably large accounts and lots of activity, and now you have a felony conviction? Bad enough your CFO has a felony conviction. Now you have felony, but the banks have a duty to obviously preserve their own. They have risk management programs. They have anti-money laundering programs. They have to preserve their own safety and soundness, and so they should be doing a review of a company that gets convicted. Presumably, they did a review of a company that got indicted. There are also loans, so who knows what that impacts? But clearly, the organization has made the calculation that they don't care as much as lots of other companies might care about the consequences of this.
What could the sentencing be other than just a felony conviction?
Very low. It's very low. It's complicated because there's 17 counts, but typically the maximum penalty for a corporation is a $10,000 fine per count, which is nothing for the Trump organization. But here there are some tax counts. So those have to do with the amount of tax loss. So I've heard it tossed around that it could be, hundreds of thousands of dollars for the tax counts, and then $10,000 each for the other counts. So it's not going to be a material number for the Trump organization at all. There's also a conditional discharge. So, a creative judge might say, I'm going to issue a conditional discharge and I'm going to make you make some changes or implement a compliance program or put in a monitor. But the law is in New York, not that strong. If you violate that conditional discharge, your penalty is a $10,000 fine, the maximum fine. So it's not going to matter. So
speak to the Tish James, the Attorney General of the state of New York, who is bringing this big, giant civil case against the Trump organization. How does any conviction impact, or any appointment of a special master or anything like that? How does that interplay with any civil, what's happening on the civil side? If you have any thoughts on that.
Well, there wouldn't be a special master in the criminal case, right? There's a special master now in the Florida case that we can talk about.
Not special. I mean, go ahead. Yeah.
A monitor. There's a monitor in the.
Yes, I meant monitor.
Yeah. No, there's a monitor that's been appointed in the civil litigation itself, and that's because what the Attorney General did was not just sue the organization for fraud, but it's this jurisdiction that the Attorney General has that has to do with persons, including legal persons, companies that engage in persistent fraud or illegality. You have to kind of do that over a period of time when you're conducting business in New York. And so you can get money damages, but you can also get injunctive relief, which means you can ask the court to order the company to do or not do certain things. And so that's a very, very powerful law. And so the criminal case, I can't remember if the organization is a defendant. I think it is in the civil one. So this can be used against it. But more importantly, the civil case is so much broader than just the Weisselberg tax scheme. It's Weisselberg and one other employee, by the way. But just the tax, it's so much broader. It's all about valuation of properties and lying to insurance companies and lying to banks, and I think lying to the IRS as well. It is a complex case that spans many, many years and has, a couple of $100 million at issue, I think, much more than this case, which is relatively small. It's also civil, so the burden of proof is much lower. So the Attorney General, will have presumably an easier time of it than the DA.
Yeah. All right. So turning now, unless you have any other thoughts that you want to say about the trial, and otherwise we'll go to our next topic.
No, there's just a lot of trials, a lot of proceedings surrounding this guy and his company. I mean, I just read that the Attorney General's case is now scheduled for trial in 2023. I mean, that's in less than a year. So it's going to be a lot of trials.
A lot of trials. Well, hopefully.
And Trump took the fifth in that case, right? When you take the fifth in the deposition, that can be used against you. So that's going to be used against him in that trial. Doesn't mean he loses automatically because of that, but it can't. Unlike in a criminal case where you can't mention it, or it's a mistrial. In a civil case, you can absolutely say, that guy took the fifth. He wouldn't answer questions. The judge's going to tell you. You can use that against him. What does he have to hide, right? That's that's only human. Whenever we hear somebody says, "Oh, I'm not going to answer that," you think, "All right, what are you hiding?" You can't do that in a criminal case. That's dirty pool. Prosecutor can't do it. In a civil case, fair game.
What is the impact of his declaration of his candidacy on the civil case, the Attorney General's Tish James's case that we just talked about?
Well, it shouldn't have impact beyond scheduling, right? I mean, I think that in all cases, lawyers and clients will ask judges to accommodate their business schedules. And it's an aggressive schedule to have a trial next year for this case. Civil cases don't usually go to trial that quickly. And again, this is a case brought under that law about persistent fraud and illegality. So there is a good reason to bring it to trial relatively quickly. So presumably they're going through discovery now. But I don't think that certainly the state judge's instinct is going to be, I don't care that you're a candidate. We've got this case and it's a legitimately filed case, and, maybe they'll move to stay it, but I don't think there's any ground to move to stay it 2 years before a presidential election. Different, of course. Now, even if he was president, he might not win a motion to stay. We learned that in the Paula Jones case. The Supreme Court said, forget it. You have no automatic right to stay a civil case if you're the president. So I don't.
Especially, because if it was conduct that happened, outside of your presidency prior to. Yeah, exactly.
Exactly right. Both of those things. So.
Yeah, no. So that's going to be a very interesting thing, I think, to watch of how the judge, and if I believe the reason it's on such an aggressive schedule is because of the election. I think that is the reason that the judge is pushing that now. Would you agree with that?
I do agree with that, but I also think that unlike a regular civil case, like these defamation cases that are kicking around with him, there's a good reason, a good statutory reason to put it on a fast track. So I don't see any sort of, the judge can say, look, this is about persistent fraud and illegality. I've granted interim relief before you've been found liable of this. I've granted a monitor because I don't trust you. So I want this to go to a judgment or a resolution as soon as possible. I think that's perfectly reasonable.
What are your thoughts on when Tish James did her big press announcement announcing the civil case, and she said, "I'm referring. I believe that I uncovered that crimes were committed, and I'm referring it to the Southern District." That was a surprise. That shocked me, only because we all know that the Manhattan DA's office was doing this jointly with Tish James, and obviously had a criminal investigation happening. To me, it just spoke volumes and kind of signaled that the criminal case at the Manhattan DA's office is dead, and that she was asking the Southern District to take it. Did you have that same take? Yeah,
well, there's a complicated number of issues there. When I was a prosecutor, particularly when I was supervising different programs, it was a pet peeve when a different agency would sort of tell the press or announce publicly that they're referring a matter to us before they've told us, right? My refrain in those conversations with those agencies was, how about you pick up the phone next time? Because there's all sorts of things that can happen that can hurt an investigation when all of a sudden everyone knows it's public. Much better to have the Southern District, if they're going to pick up an investigation, get their ducks in a row, have some time to plan, review the evidence she's referring. So ordinarily, I don't think it's a very good idea for an attorney general to say, I'm referring this now, and do that publicly. So I hope she told the Southern District in advance. I doubt it, because she did the same thing in the Cuomo thing when she referred those misdemeanor sex abuse matters to the local DAs for investigation. So I don't know why, but that's what she did. Now, you asked Southern District, so does that mean Manhattan DA's case is dead? I mean, the new Manhattan DA pretty much signaled that the case was dead earlier in the year. He didn't say that. He said the opposite. The case is still ongoing. But you don't pull, as you know very well, Karen, you don't pull the plug on a special grand jury that's already moving forward on filing charges or on presenting charges, complex charges, unless the case is pretty much gone. You're pretty much conceded it's gone. Now, he did say if more evidence comes out, he'll go back. I don't know where that's going to come from. I don't think Weisselberg is the key, but who knows? So it may well be that she went federal with her referral because she just knew that the Manhattan DA was not going to do anything criminal.
Do you think the Southern District has a criminal investigation because of that referral?
I doubt they're chomping at the bit to pick this up. I think this has been picked over territory, and I don't think they really want to get distracted from their regular mission. So if I were them, I'd want to find a way to beg off.
So interesting. Okay, so let's pivot now to the 11th Circuit. So on Tuesday of this week, the 11th Circuit and a 3-judge panel heard oral arguments in the Mar-a-Lago case where you know what? I just remembered something. And so I'm going to interrupt myself and I want to go back to the Trump org trial. I read that Alina Habba was in the audience during the testimony. Did you see that?
I did. I saw that she was there.
I mean, what did you think of that? I mean, do you think she was trying to put pressure on some? I don't know. I just thought it was a little bit.
No, I can't read it. I can't read anything into it. I mean, she's a lawyer representing Trump. She came to see the trial. The reporters keep saying how the courtroom is almost empty, which is funny because, this sort of supposedly high profile trial. But I think when reporters and the public hear tax returns, they kind of file out of the courtroom. It's not that exciting. Well, second only to antitrust.
I know. Well, someone else. I read somewhere else today that that 3 of the jurors were visibly falling asleep. It is like these white collar cases, which I've always said to you, they are a little painful. So as you know,
it can be exciting if you package them the right way.
I don't know. I really don't know. I find them very painful, but. That's why I always preferred the violence, right, Dan? That's where you and I were very different chief assistants.
You were really good at the blood and guts, and particularly sex crimes. You were a talented sex crimes prosecutor, but I did focus on fraud and corruption and organized crime. That was just the way our interests fell.
All right. So I apologize to myself for interrupting myself. Going back to the 11th Circuit. So there was the oral arguments in whether Judge Eileen Cannon, whether she kind of went over her skis when she appointed a special master in the Mar-a-Lago case. And it sounds like from the reporting and the questions that the judges asked that they're going to overrule that. Do you agree with that assessment?
Absolutely.
So then what happens?
Note that it's not about the special master. It's about whether she can have jurisdiction.
It's about whether she can assert that equitable jurisdiction in the first place. Yeah.
Yeah. So I mean, thank God somebody's actually going to talk some sense. I mean, people.
Well, before you say that, let's break it down for what that is. What is equitable? So the way I understand what she did, and correct me if I'm wrong, basically, until there's an arrest, a judge doesn't typically have jurisdiction over a matter, over a criminal case, correct? Is that, and she said, but this case is so unusual and so special that I'm going to say, no, I'm going to get involved. Is that?
Well, there are certain statutory grants of jurisdiction to judges before arrests, most significantly search warrants, eavesdropping warrants, things like that. So judges do have some role when they're specified by law. Here, the question is, it's not specified by law. That's why it's equitable as opposed to at law. And so equitable jurisdiction is what Judge Cannon exercised, but it's just practically, I think it's unheard of in this kind of case for a judge to have interfered to this extent in the middle of an investigation. There's so many issues at play here. One is just separation of powers. The executive branch gets to investigate, and this is not a civil law country. In like Italy or France or places in South America, there's an investigating judge who actually does the investigation and calls witnesses. That's not what happens here. So the other thing that's going on is just, it's very frustrating for lots of people, very frustrating for me too, is boy, does Trump get special treatment that no one else gets. I'm put aside this case for a minute. The fact that he was able to tie up a subpoena to his accountant for tax returns for 2 years before it went to the Supreme Court by filing a lawsuit in federal court, that's never happened. I mean, you know how many times the Manhattan DA's office subpoenas accountants for tax returns of companies and people? All the time. Who else? No one else has ever been able to challenge it the way Trump did. So he got really special treatment there. And by the way, he delayed it 2 years. That meant that it was delayed far enough that Cy Vance didn't make the decision till December of the year he was leaving office. And by the time, it was going to the grand jury, it was January and February, and the new DA said, I'm not doing it. So it really, really mattered for him. So back to this, a regular defendant, if your home or my home were searched, Karen, and people took our computers or our records or our whatever it was, our guns or our drugs, even assume that we were very bad people, that we would not get to do this. We would not get to do this. But Trump, of course, gets, somehow files it in Palm Beach, gets to the right judge, and she upends this whole concept of equitable jurisdiction by allowing it to happen in a case where there was the standard is callous disregard for constitutional rights by the government agents. Everything I've seen is they were pretty good, and they pretty much regarded his constitutional rights. And P.S. even Judge Cannon agreed in her decision that there was no callous disregard, but she still went forward and grabbed this equitable jurisdiction and basically commandeered this case. And for a moment, she tried to stop the agents and prosecutors from using some of the evidence in a criminal investigation. That's crazy. So it did not go well yesterday for Trump's lawyers in the appeal of this issue, of this equitable jurisdiction issue. And I would expect, I'm not alone in this, I would expect a relatively quick reversal of Judge Cannon.
Yeah, I was reading that his attorney, Mr. Trusty, was arguing in front of the 11th Circuit saying, calling it a raid, because that's, I think, trying to show that this was sort of an egregious thing that they did. And even the judge on the 11th Circuit would not allow him to stopped him from calling it a raid. It's not a raid,
Yeah. It's funny what happens when you use that terminology not on Fox News. It's always been a pet peeve of mine when people say raid. Even reporters, headline writers say it. It's not a raid. It's the execution of a search warrant lawfully obtained from a judge. You can challenge the warrant. You can say they were wrong, whatever it is, but it's just not a raid. So yes, that's a very good point. I'm glad it happened.
Who were the three judges on the panel? And do you know who appointed
one
them?
was William Pryor, who was an attorney general down there before Trump appointed him. The other two were also Trump appointees. I don't remember their name. This is the 11th Circuit that's down in New Orleans, and it covers Florida. Sorry, no, New Orleans is the 5th Circuit. 11th Circuit is in Atlanta. Apologies. And it covers Florida. They used to be together. The 5th and 11th Circuits used to be the same circuit. So it covers Florida and 3 Republican judges. It's Trump started really loving the word rhino when he couldn't co-opt Republicans to do what he wanted. And I'm sure he's furious that 3 judges that he appointed are not doing his bidding. But, that's let's be thankful that there are judges who
actually just follow the law. Yeah. And
these are conservative. These are conservative people. I mean, Judge Pryor was a very conservative lawyer, politician. I don't remember if he was elected, but I think he was. And he, I think in part they're thinking to themselves, well, geez, if we do this for this guy, then the drug dealer is going to come to us next, or the regular tax evader or fraudster or corrupt
regular tax evader.
Right. Just the normal person who doesn't, who files false tax returns or makes phony deductions, whatever it is. White collar crime is a broad topic. There's a lot of different kinds of crimes.
So let me ask you a question about, so you said something that I've been saying where you said nobody else would be treated like this, the way he's getting away with, using the court systems and delaying things and going to the Supreme Court. How many times can this guy go onto the emergency docket of the shadow docket of the Supreme Court and get them to say yes, no, yes, no? It would take decades for people to make their way to the Supreme Court the way Donald Trump has. So, he's clearly being treated differently than you and I would. And one of the things that I have said, that is my pet peeve on being treated differently is, Dan, you and I both, as part of our job at the Manhattan DA's office as chief assistant, because we would often, handle and supervise terrorism cases and other sensitive cases, that we had to get top secret clearance, right? And that's like a whole thing. So we had access to classified documents, right? And we'd see them. And then you and I both left the office. We packed up our boxes. We went home. We took our our penal law and our plaques, all the plaques that I see on your wall behind you, that used to be in your other office. We take our books, might take our files on legal research into, whatever, legal research we did. But if we had 103 classified documents shoved in there,
you'd be in lockup. You'd be in lockup
Yeah.
in
Right?
a heartbeat. And
Right?
I think everybody who's ever been trained on I had top secret clearance in the U.S. Attorney's office, not in the DA's office. But anyone who's ever had
No,
it,
I had it in the DA's office.
and been trained on it, anyone who's ever been trained on it, it's like they scare the hell out of you.
Yes.
so it's like,
But imagine if we had that.
And we prosecute
had
people for nothing. Not nothing, but we prosecute people for possessing a few documents that are classified. Now, there is one difference. He has a potential defense. I think it's bogus, but he is a primary classification authority. He's the primary classification authority. So it is in fact true that he can declassify documents. Now, one would think that he would have asserted that in response to a subpoena. So, I think it's nonsense. And if he wants to assert it, he certainly can assert it. But it's not like asserting it on Fox News. As I said before, when you do it in court, you're subject to problems if you're presenting false evidence. But he theoretically, of course, he could declassify. Not that that's necessary for all the charges that are under investigation. Some of them just have to be national security or defense documents.
So let me ask you this question. There are some who would say, especially with the January 6th and election interference, that, let investigations, as we know, especially in white collar cases, take time. Sometimes they take years. You have to go through, you subpoena documents, you look through the documents, you interview witnesses, you then get other leads that you then issue more subpoenas, and then you talk to more people, and then you get even other leads, and then you keep going, and then you start flipping people, right? You start making deals with them so that they'll cooperate against the people above them, et cetera. And so it can take a long time, and people get frustrated by those cases. And there's a lot of people who think that Merrick Garland has been very slow on his numerous investigations into Trump. The Mar-a-Lago one in particular, how complicated is that? And why haven't the handcuffs been put on him and him been prosecuted? Just, can you explain? Do you agree that it's taken so long?
Well,
why is this so complicated?
Conceptually, it's moderately complicated. You just have to index a lot of evidence. You have to track down what it is. So it's not highly complicated. It's also not a simple case. But there's so much we don't know, since the stuff is by definition confidential. So, that's a classification level. It's classified, or at least confidential for other reasons. And so I don't know what's in there. So it's possible that the government is being a little hesitant because they don't want to expose these secrets to public scrutiny, which they would have to do at some point in a trial. So I don't know, or they would be worried Trump would do it in a trial. And so they may be,
because these documents would have to be entered into evidence.
I'm not an expert on there's a Classified Information Procedures Act, but yes, I'm pretty sure that
CIPA, right?
The documents CIPA, it's called, yeah. The documents themselves, I'm pretty sure, would either they themselves or their description would have to be there, but most importantly, it would have to be given to the defense. And of course, the government doesn't want to do that. They don't want to trust.
So you think that's the delay.
I think it's a possible delay. Yeah. If we knew more about what the documents were, I think we might have a better idea as to what the delay is. But like I said, conceptually, it's not that hard. I'm sure they've done most of the hard work. I'm sure there are deep catalogs of what this stuff is, page by page, where it was and all that. So I don't think that the new special counsel, Jack Smith, will have a particularly hard time getting up to speed, because when you're the chief prosecutor, they'll give you detailed memos. You can ask questions, you can have meetings, but he's not going to be interviewing witnesses on a daily basis like the line prosecutors have been doing. So I think he can get up to speed quickly. This classification question comes up in these national security cases. I was not a national security prosecutor, so I don't have all the ins and outs, but I know it's an issue.
Okay. Because, again, that's a very different issue than what some people think, which is, oh, these things just take time, let them do their job. And
They
I
also
do think
do.
that's the
They
case
also
with
do. They also do. I
Pardon?
mean, his lawyers are witnesses here, so that by itself would take a few months to resolve. Are they taking the fifth? If they are you going to grant them immunity? If they're not, are they asserting attorney-client privilege? If they are, as to what? Or do they have a good point on attorney-client privilege? I mean, those things have to be discussed and hashed out. But his lawyers are definitely witnesses. I would not want to file this case without having them locked in to what their version of events is. Locked in usually means putting them in the grand jury or having some other version, some other written documentation that they can be confronted with if they change their story at trial.
And so you would expect that to be something that Jack Smith, the special prosecutor, is going to address. Let's talk about Jack Smith. Jack Smith is somebody that I worked with in the Manhattan DA's office. I started in the early 90s, and so did he. And we coincidentally were in the same trial bureau. We were both in Trial Bureau 30. So, we came up together with the same friend group. We were trained the same. We were both very junior at the time, and he was just coming up, and so was I. So he wasn't the Jack Smith that he is now, but even at the time, he was kind of everyone. He had a reputation as being kind of, somebody very special and very, very thorough and excellent, and someone who's going to go somewhere. And so Jack Smith was a superstar, even as a very young prosecutor in Trial Bureau 30. And, he was someone that as we've watched his career since then, he left and became a federal prosecutor and worked for the Eastern District. He also worked for the Department of Justice, where he prosecuted and supervised public corruption cases. He's been worked for the International Criminal Court in The Hague, prosecuting war crimes, and now he's the chief prosecutor for Kosovo's war crimes. And, he's just somebody who I wouldn't even know his politics. He's a prosecutor's prosecutor, and he is he epitomizes somebody who does his job without politics, without fear or favor. And if there is, he knows how to also make a case. He knows how to both investigate and make a case that can then be prosecuted. And so when I saw that he was going to become the special prosecutor in this case, I breathed a sigh of relief, because if there is a case to be made, he is the guy who could do it and would do it. And at least whatever the decision is, I would have complete trust and faith in that decision. But I was also heartened, because I thought, would Jack Smith come back from Europe and, upend his whole life and his career if he didn't have some, ability to potentially prosecute this case? Do you agree with that, or what are your thoughts? You worked with him, right?
Yeah, I did overlap with him barely at the DA's office when we were young prosecutors, but I didn't know him at the time. I didn't meet him until he became a federal prosecutor in the Eastern District. And it's funny you use the word superstar. Prosecutors, supervisors would toss that word around a lot as to people who were, exceptional prosecutors. I used to feel a little bad because I didn't want people to know we were using that as to some and not as to all, just because, some are more superstars than others. But Jack was definitely a superstar. When I knew him, he was a violent gang prosecutor in the Violent Criminal Enterprises section of the Eastern District U.S. Attorney's Office. And he was, again, not to take anything away from the others, but he was pretty much the go-to, best violent gang prosecutor. There was another one from the Manhattan DA's office who was fantastic as well at the time. So they were both kind of up there. But Jack was really kind of the go-to guy. And I used to lament that back then, the department was big on the death penalty being considered in every gang case. And I'm personally opposed to the death penalty on policy grounds, but we had to carry it forward, and that's fine. We had to do it, but it wasted so much time. I used to use Jack as an example. If a Jack Smith didn't have to do all those death penalty memos and committee meetings and all that, he could be doing 3 times as many gang cases. So He really was exceptional in the Eastern District when I knew him. If I were Trump and Trump's lawyers, I would not think this is a good piece of news for them. And unlike Bob Mueller, where, I mean, Bob Mueller was also beyond reproach, had a great reputation, was a lot older, but he had been around longer. He had had 3 political appointments, Bob Mueller, so which meant he had to meet senators, meet political people, and that at least created some fodder for Trump to do his usual stuff. It was nonsense, but it was fodder. Jack has never had a political appointment. His appointments have all been career. He was a U.S. attorney. He was an acting U.S. attorney for a while in Nashville because he was a career person who was the first assistant U.S. attorney and then was pushed up when the U.S. attorney left. So he's had very important jobs, but he's never been in a political position. And I suspect what you suspect is that he's completely not political. I would doubt he's enrolled in a party. He's personally kind of, a conservative type lawyer. I don't mean that politically, but he's a, button down lawyer. But he's also, he's a nice guy. I mean, I don't know what else to say. He's just a very good choice for this. And if I were Trump, I would not be happy.
Well, Trump's doing his usual when he's not happy. He's going on the offensive and attacking him. I think he attacked his wife even, which is ridiculous because, she's a documentarian. And I think she produced a documentary into Michelle Obama. And I think he's, making something out of that. And whatever. He's doing his usual.
He's going to do what he's going to do, but I don't think he can call Jack an angry Democrat. I don't think he can, maybe he can make up a nickname for him, but Jack's going to let that, bounce off. It's not anything he cares about. He's going to keep his head down. He was never, by the way, never kind of a press hound. I never knew him to sort of, be looking for publicity. I mean, he's a guy who's going to do his job. Yeah,
I agree. It's not about him. It's not about him. It's not about ego. It's not about any of the negative things that could potentially,
Yeah, I mean, look, if he files charges, he's going to want to win. That's for sure. And he's he was never a defense lawyer, so he doesn't have that perspective. And I think that's valuable in a prosecutor. So he doesn't have that. But he's also somebody who's a smart prosecutor. He wouldn't file a case that he doesn't think he can win. And once he files it, he's going to want to win it. If I had to guess, I'd say if there is a charge and there is a trial, he's going to want to be part of the trial team.
Oh, for sure. Absolutely. When do you think it's so how long do you think it's going to take him to get up to speed? Do you think that this slows down the investigation, speeds up the investigation? What are your thoughts on that?
They've made a point. He and Garland have made a point of saying that this is not going to slow down the investigation. I believe them, first of all, because it's not the most complicated case in the world, as we said. And secondly, because Jack's just very good at getting up to speed. So if they have a prosecution memo and the search warrants available for him and a few briefings, a week, he'll be up to speed in a week.
On the Mar-a-Lago one. What about on the election interference in Jan 6?
That's a lot more complicated.
I was going to say that case is more complicated. That one I agree with. Yeah. It takes time.
And a lot of legal issues wrapped up in there, First Amendment issues. So luckily he's going to have an unlimited staff if he wants it. I mean, he's going to have access to the Justice Department's best minds and experts on all these doctrines. I mean, Jack's not going to have to look up equitable jurisdiction like I did. He's got people from the Solicitor General's office arguing this. So, he's gonna get up to speed very quickly on this stuff.
Very quickly. Yeah, that was my take.
And he's going to throw out a million ideas. He's going to throw out a million ideas. He's going to say, why didn't we subpoena that guy? Let's throw that person in the grand jury. Let's get those documents. We need 5 more search warrants. Let's get that guy's phone. That's what he's going to do.
So I was reading the statute that creates the special counsel, and because I wanted to see how vulnerable this position is now that the House is going to become Republican, and whether or not there's any vulnerability. And what I could tell is that Merrick Garland can assign as many staff as he wants, and in fact is obligated to assign a certain enough to to handle this matter. But if the Republicans in the House wanted to play games with the Department of Justice's budget or the special counsel's budget, could they? I mean, how does that work? If, let's say, Jack Smith wants to hire people or wants to bring on outside people or bring in more people from the Department of Justice, is there any vulnerability with the House turning Republican, if you know?
Got to get the Congressional Budget Office to answer that question. I think my gut is that the Justice Department's budget is so huge that they'll find the resources and the personnel, and it's impossible for Congress to cut out specific things without passing a law. They could say we're eliminating special counsels by statute, but if we're just going to talk about budget, I don't think so. The bigger problem that the House can cause is oversight investigations, and that's something that I know the department is gearing up to defend against, as it's done before.
Right. I have to say, Dan, you are and always have been the smartest lawyer, if not one of the smartest lawyers, if not the smartest lawyer I've ever known. And I've always gone to you with questions, and you've always known the answers in detail, those questions. So the fact that you would say you have to ask the Congressional Budget Office that question, I think it's the first time you didn't know not only the answer, but the history of of all of it. So no, it's true. It's really true. Anyway, so
you're fabulous.
Any other thoughts on the special counsel investigation now before we wrap up?
No, I think that the regulations you talked about are pretty detailed. They were put in place after the independent counsel statute lapsed, and I think that there's a modicum of protection that you get by having a special counsel. If it's not as important that the House changes, it's if the presidency changes. So if Trump or somebody else comes in, there is at least some amount of protection for the special counsel. They can only be discharged for cause. I don't put it past Donald Trump to do anything, but it at least makes it exacts a political price if you get rid of a special counsel.
So basically what we're saying, or what you're saying is, or I'm going to interpret from what you're saying, is that Jack Smith is going to have to make a decision one way or another before Donald Trump, before the election, before the next election.
Well, I think he should. That would be only prudent, but I don't know that he has to. I mean, I think that if there's a Republican elected and the person is the kind of person that might want to fire a special counsel, which, remember, even Donald Trump didn't do, notwithstanding the fact that he wanted to fire Bob Mueller, he didn't. So, but if somebody comes in as the kind of person that wants to fire a special counsel, they still have to have cause. They still will. It'll still cost them politically in some way. But so if I were Jack, I would file whatever indictments there are to file beforehand, because it's always harder to not just fire a special counsel, but also dismiss an indictment. So
do you agree with Merrick Garland's assessment of that he needed to appoint a special counsel once Trump declared his candidacy on November 15th?
I think it could have gone either way. Remember that the special counsel gives the attorney general some level of insulation, but not complete, because as the regulations say, and as I think it's a constitutional issue, the attorney general ultimately has the ultimate say in anything the special counsel does. There are sort of roadblocks in the way of overruling special counsel decisions, but ultimately the decision is the attorney general's anyway, even though he has a special counsel.
Right. And would the special counsel, let's say the special counsel files an indictment and Donald Trump is arrested and prosecuted. How does that impact his candidacy?
Nobody knows. It's completely unprecedented. It's never happened. So he'll say that the case should be stayed pending the presidential election, no doubt, and we'll see what the Justice Department would think. I mean, I would think it would be pretty hard to be trying a case in the summer of 2024 when there's debates and conventions and heading up into an election. So it all depends. Look, the Mar-a-Lago case, as we've said, conceptually not that difficult. So potentially that one, I mean, if that indictment were filed next week, you could easily see that case being tried, next summer.
Yeah. Well,
and they've gotten a big head start on the search warrant issues. So
yeah, you're right. So much has been litigated already.
Exactly.
All right. Well, any final thoughts before we
It's going to be a
say
fascinating next couple of months. I mean, it's almost like the Trump legal issues are multiplying. We haven't even talked about Georgia. I mean, there's so much stuff going on. So looking forward to reading about it, seeing it, and listening to your commentary, Karen.
Yeah, well, hopefully you'll come back, and you'll talk to us. I love having you on the show.
Very happy to.
All right. Well, thank you so much, Dan, and just really, really appreciate that you were here, and your insights are just absolutely invaluable.
Thank you. Great to be here.
All right. Thanks everyone for joining us tonight. What an interesting and fun night we had with Dan Alonso, who gave us an hour of his brain to talk about all the legal issues that are going on surrounding Donald Trump. I hope to see everybody on Saturday night when we do the regular Legal AF, and next week, and because we drop every Wednesday and every Saturday. Don't forget to check out the Legal AF merchandise and to subscribe on YouTube to the Midas Touch channel. And to also, it's great when we get audio listens. So please also remember to listen to this wherever you get your podcasts. So thank you for joining, and shout out to all the Legal AFers and to the Midas Mighty.